Welcome to the Just Solutions podcast, where we explore relevant projects, policies, and stories from the perspective of the communities most impacted by climate change: Black, Indigenous, people of color, and those with lower incomes. I'm your host, Aiko Schaefer, Executive Director of Just Solutions. In today's episode, we explore the role of the National Environmental Policy Act, also known as NEPA, a federal law that requires agencies to assess the environmental impacts of policies and projects. I'm joined today by Hannah Perls, Senior Staff Attorney with the Environmental and Energy Law Program at Harvard University, and Idalmis Vaquero, Senior Policy Analyst here at Just Solutions. Welcome, Hannah and Idalmis, to the Just Solutions podcast.
Thank you so much for having me.
Yeah, thanks for having us.
So, Hannah, what brings you to working on environmental justice?
I come at it from a couple different angles. My mom was actually a heart doctor here in Boston at Children's Hospital for over 3 decades. And we talked a lot about the limitations of medical interventions to really get at the environmental health factors that drive a lot of her patients' illnesses and keep them coming back despite, all the best technology and being at the best hospital in the world. So I knew early on that this was a problem. And when I graduated college, my first job was actually cleaning up Superfund sites. And so my work at EELP is very much about how do we support EJ organizations. We are a legal research center inside Harvard Law School. So we are an academic legal think tank. We seek to support EJ work that is being done by movement organizations.
You have been such a good partner to us and have done great work in community. Idalmis, you're a senior policy analyst here at Just Solutions, and as a lawyer yourself, tell us more about how does having a law degree coupled with your lived experience with environmental justice, how do you feel those come together that make you better at what you do?
My personal experience really helps me understand that there shouldn't be a lot of limitations in the law, and that's kind of different from what we are taught at law school. Like you should fit within a certain box, and these arguments, the law can only go so far. But I really feel like my lived experience tells me that there are possibilities out there.
Today, we're talking about the recent updates to NEPA and what it may mean for environmental justice policy. So, Hannah, what does NEPA do and what problems does it address?
At the just most basic level, NEPA, or the National Environmental Policy Act, is a look before you leap law. It requires federal agencies to take a quote-unquote hard look at the potential environmental and public health effects of certain proposed actions. Now, NEPA does not require agencies to pick the most environmentally friendly option, but agencies and community and industry, they can't make good decisions if they don't have good data. And so NEPA is really the tool for agencies to gather that information and for communities and industry and whomever else to make sure they get that information to the agency before the agency decides what to do. I should also mention NEPA is really the essential scaffolding for a lot of other governmental obligations. So we think about tribal consultation, processes around a National Historical Preservation Act. These are all built into the NEPA process. And so we are just talking about NEPA today, but I want to make sure we talk about those other pieces. The one other thing I want to say is that NEPA serves a really crucial democratic function. It requires agencies to share these anticipated impacts with the public and to receive comment on those impacts. And we know that when agencies do this well, particularly when they engage with impacted communities, it can lead to more effective and efficient projects that deliver more benefits to nearby communities. And that results in less litigation, which means fewer costs and delays. So NEPA done right can actually lead to better project outcomes.
So, Hannah, do you feel that NEPA has, by and large, been an effective policy?
NEPA has taken a lot of forms over the years. I certainly will not say that NEPA is perfect. There is a lot of work that we need to do to figure out how to make it work better. That said, I think there's a lot of conversation right now where people point to NEPA and say NEPA is the problem, whether it's folks who are pro-oil and gas saying NEPA is the reason we're not getting all these projects online, but also people who are pushing for renewable energy and saying NEPA is the reason we're not getting large-scale transmission. I think that's really reductive. I think NEPA is a really powerful tool that we need to preserve because fundamentally it's about making sure that agencies have the information they need to make the best decisions. And what we need to be talking about is the right process to make that happen, we also have to talk about staffing. Agencies sometimes just don't have the staff, the scientists, the data managers, the community engagement experts to make sure that these processes are done quickly and efficiently. So I think we just need to get into the nuance of what's working and not working rather than say NEPA is all good or NEPA is all bad.
And I like how you've thought about it in terms of it being part of the democratic process and enabling us to be able to have more information. And I think what's so interesting to me is it's been around for a while and that it was signed into law by President Nixon. So at a time when it was really a vibrant time in the environmental movement, when I think we were fighting for very fundamental things that NEPA came to be. So interesting history on that front. So Idalmis, what is the relevance of this policy to BIPOC frontline communities?
NEPA is relevant to frontline communities in many ways. So first, NEPA requires, for example, an agency to consider the composition of an affected area to determine, whether BIPOC populations, low-income populations, or tribes are present, and if so, whether they may incur a disproportionate or adverse health or environmental effects. Second, agencies are required to consider relevant public health data concerning the potential for multiple or cumulative exposures in the affected population, and really recognize the interrelated cultural, social, and historical factors that may amplify the natural or physical environmental effects of a proposed action. And like Hannah mentioned, NEPA really also helps to seek tribal representation in a manner that is consistent with our government-to-government relationship, the federal trust responsibility to federally recognized tribes, and any treaty rights. And so just to highlight one of the new ways that the regulations are also expanding tribal sovereignty is that these new regulations also treat Indigenous knowledge as a form of expertise so that agencies can use it. And it also requires agencies to consider the adverse impacts on tribal sacred sites that may or may not be located within reservation land. So it really expands the level of protection for tribes. And then just lastly, agencies are required to develop public participation strategies that can help overcome the linguistic, cultural, and geographic barriers to meaningful participation and really assure that community participation happens as early and as quickly as possible so that it is meaningful and the agencies take that input into account. So just to expand on these last 2 points, NEPA is really about the community engagement mandate. And, one of the innovative ways that I've personally seen this happen is in the case of the proposed lane expansion of the I-710 freeway in LA County, Los Angeles County, which for its entire project, it was about 15 years since community heard about it and was ultimately suspended in 2021. But public concerns regarding the proposed alternatives in this project significantly changed the course of the whole process. Community members, from the very beginning were concerned about the additional impacts that the I-710 freeway would have on their communities, including air quality impacts and the displacement of homes and amenities. And in response to these concerns, the lead agency in this case was LA Metro, the main transportation agency there, and they formed a system of community advisory committees to give residents and local jurisdictions an official voice in the process. And so this kind of process helped regain some trust and buy-in from the local communities. I think one of the other ways this is a really innovative example is that when it comes to the determination of alternatives that the agency studied, under the direction of these community advisory committees, the decision makers developed an alternative that included what the community envisioned. So, for example, there was an alternative proposed with more bike lanes, safety measures, and a significant reduction in displacement. And the hybrid alternative was ultimately selected as a locally preferred alternative that the agency studied in the end. Just an example there of how NEPA has actually helped bring more public participation in the process. And the project was ultimately suspended for other reasons, but I think it showed just how we could use new innovative community participation strategies in this process.
I think we have to mention, because we're both lawyers, that NEPA is also a really important litigation hook. And I'll give a quick example. We just heard that the DC Circuit struck down permits for some proposed LNG facilities. And the grounds for striking down those permits was a deficient environmental justice analysis, and the fact that FERC then didn't provide public consultation and comment opportunities on that expanded EJ analysis. FERC, by the way, is FERC, the Federal Energy Regulatory Commission. They're an independent agency. So again, it's not telling FERC you were supposed to choose the most environmentally friendly alternative, but they are saying, FERC, you didn't do that sufficient hard look. And so it doesn't mean the project is gone, but it does mean that the project is delayed. And I'm not saying that's the reason people bring these lawsuits, but it is a very, very potent tool for environmental advocates who want to make sure the agencies are taking all of these impacts into account before they decide to, for example, greenlight the LNG facility.
When you think about the history of NEPA, can you help lay that out? I thought it was rather interesting. President Nixon signs NEPA into law on New Year's Day. And at some point, and correct me if I'm wrong, right, that the EJ elements kind of happen a little later. Can we fill in a little bit of the history of NEPA? Because it seems like a policy that had great initial design and intention. It seems like it has been improved. It has been suspended. We're in another moment in time right now. Can one of you fill in a little bit of that historic arc around NEPA?
So NEPA is the statute. It is the law passed by Congress. That law also created the Council on Environmental Quality, or CEQ, which is an office inside the White House that is tasked with implementing NEPA. So when we talk about all these rules, we're generally talking about CEQ's rules that clarify and fill in a lot of the gaps left by the statute. The statute itself is pretty short as environmental statutes go, so a lot gets filled in by the agency. That also means, though, that a lot of those gap-filling pieces can shift dramatically if the administration's policy priorities shift dramatically. And that's what we saw in the last 4 years. So we've actually been relying on the first NEPA regulations, which were issued in 1978. We relied on those all the way up through 2020. So we had the same NEPA rules for over 4 decades. Then when the Trump administration came in, one of their priorities was to overhaul NEPA. And so those rules that were issued in 2020 were very much about narrowing the types of impacts that agencies had to consider, making reviews go faster, and also limiting judicial review and the types of comments that agencies had to consider. So it was really about shrinking this process as much as possible. When the Biden administration came in, they said, we really want to address this rollback. And they did that in 2 phases, which is why today we keep talking about the phase 2 rule. So that phase 1 rule, which came out, I think in 2022, was mostly about repair. Like, how do we just get at the most egregious parts of the Trump rollback? The phase 2 rule is really where we see the Biden administration try to codify their environmental justice priorities in a lot of the ways that Idalmis flagged. So we can get into what those changes are, but I wanted to emphasize how a lot of these big pendulum swings in what NEPA does or doesn't require have happened in the last 4 years because so much is up to the implementing agency in terms of what impacts are important. Should you consider greenhouse gas emissions at the national scale, at the global scale? Does EJ matter? What kind of effects matter? Do we want to consider cumulative impacts? All those gnarly questions are answered by CEQ.
It's interesting because NEPA is signed into law by a Republican. By and large, it kind of functions in a particular way and has the impact generally that it was intended. We have a Republican president come into office, and then there are what sound like significant changes made to NEPA. What's the criticism of NEPA? I mean, what is the rationale for the change that was proposed under the Trump administration that really made changes to NEPA? What is their argument for those changes?
Sure. I think the argument is NEPA is delay. It is delay with no benefit. And it is a tool for opponents of these projects to just delay until it becomes too expensive to implement it at all. So I think the counter to that is not just for argumentative purposes, just factually, there's a real value to gathering this information and making the most informed decision possible. You don't want to gather information forever, but that's not what we're talking about. We're talking about actually considering how this project is going to withstand the impacts of climate change in 50 years. that matters when we're talking about spending taxpayer dollars on infrastructure, as an example. I was trying to explain NEPA to my husband, who is not a lawyer. He's a musician and music teacher. So think about any major decision you make in your life, whether it's who you marry, where you live, what job you want to have. There's a certain amount of information you want to collect and consider and sort of check it against other people before you make that decision. And that is what NEPA does. I think fundamentally, we have political disagreement about how much information that requires and how long that process should take. But one thing I think that doesn't get a lot of play is that most projects in this country are sort of major federal actions. That's the key word in the law. Those don't get the full NEPA review, or what we call an environmental impact statement, or EIS. The vast majority, over 90% of projects, go through a streamlined process. It's called a categorical exclusion, where an agency has said, you know what, this type of project in general, it tends to not have a significant effect on the human environment, so we don't really need to go through this big process. The vast majority of projects get that treatment. The phase 2 rule includes steps that agencies have to take to make sure that that categorical exclusion is applied appropriately. But I think the critiques of NEPA fail to grapple with those two things. One, the reality that most projects sail through this process. And two, there is a real value to gathering that information. And in particular, to Idalmis's point and the example that she offered, you can make better decisions when you have that information. You can adjust the project. You can choose a different alternative that fundamentally has better benefits to the surrounding community, might have better health impacts, might be a better use of taxpayer resources. And if more people agree, you're not going to have as much litigation and delay on the back end.
So that is, to me, also about transparency, the recognition that government works for the public interest. And I think that often is the difference, is whether or not government is working for corporate interest or whether it's functioning for public interest, and whether or not we as taxpayers get to see how our money is spent and what impact it will have or not. And so that is a very distinguishing feature of what we're talking about here today, and such an important conversation that we're having together. What are some of the changes under the phase 2 regulations for NEPA?
So one of the big changes that came out of phase 2 regulations was that CEQ provided and codified a definition of environmental justice and also communities with environmental justice concerns. So I think these are two really great big points that for the first time, we get something codified that kind of says, this is what we mean when we say environmental justice. So in addition to defining environmental justice and communities with environmental justice concerns, CQ also describes what meaningful engagement is. And it shouldn't be just a simple check the box exercise, but agencies will be required to conduct engagement with appropriate planning and active dialogue with interested parties. So now they'll have the flexibility to determine what methods are appropriate to achieving this collaborative and inclusive process so that it meaningfully and effectively engages communities affected by proposed actions. And I'll also add that CQ now requires agencies to consider the primary language of the affected persons when determining the appropriate notification methods to use.
So one thing to mention is Congress actually amended NEPA for the first time in 2023 as part of the debt ceiling bill, Fiscal Responsibility Act. So there are a lot of changes in phase 2 that are a response to those statutory changes. So that includes codifying new page limits and new time limits. So how many years an agency has to do an EIS or an environmental assessment, which is a shorter environmental document, or an EA. One thing to flag on those page limits, those don't include footnotes or appendices. So I don't think we're going to get less information, even though we have those page limits, because lawyers know how to use their footnotes and their appendices. And so I just wanted to flag that those amendments happened, and so some of the changes are a result of those amendments. My two other favorite parts that we haven't talked about yet, and I will flag that our program has a much longer explainer that goes through a lot of the EJ-related changes in the phase 2 rule, and we can link to that in the show notes. One thing that Idalmis mentioned that's really important is the consideration of effects, adverse and disproportionate effects on communities with EJ concerns. The important thing is when that consideration happens. And what the phase 2 rule does is it changes a lot of these threshold considerations when an agency is still deciding, do we have to do a full EIS, or can we do an environmental assessment, or we can do that categorical exclusion. So now those EJ factors, as well as effects on the rights of tribal nations, on important tribal cultural sites, those all happen at the very beginning when an agency is deciding how significant are the effects of this proposed action. So that's one, is putting those EJ effects right up front. The other thing I wanted to flag is something called mitigation, and it has a lot of meaning in climate world. In this case, mitigation is the reducing of potential effects. So for example, an agency might say, you know what, we want to do this project. We see it's going to have a bunch of impacts, but we're going to try and mitigate those effects by doing X, Y, and Z. What the rule does is it requires agencies to show that they can enforce that mitigation if the agency relies on that mitigation to say, we're going to do a less stringent analysis. So they can include mitigation, but if they don't rely on it, it doesn't have to be enforceable. But if they do, it has to be enforceable, meaning it's included in the permit language or some other mechanism, and they have to create a monitoring and compliance plan. So this is really important to make sure that agencies actually follow through on the mitigation of those effects if they don't do an as stringent environmental analysis.
That makes a lot of sense. And so when you talk about enforcement, it's about whether or not we are following the rule of notification and creation of information. And I think what's interesting is for the pieces that you laid out, Idalmis, is that it includes the consultation, the transparency, the engagement level that we think is so important as EJ advocates, important for communities that are often not notified, not engaged, not consulted, have a role. And we would argue, as a result, that information allows us to make better decisions and also allows us to be able to, find other tools in the policy toolbox, so to speak, to get the results that we're looking for a cleaner environment and healthier communities for sure. So what is the status of implementation? So there's phase 2 regulations. So where are we at on that?
So Republican-led states, 20 Republican-led states filed a lawsuit in the District of North Dakota. But it's before a Trump-appointed judge, and what they've argued is that Phase 2 rule violates NEPA, a host of other federal laws. It's a major question. They're really throwing the kitchen sink at this thing. They've also included some pretty egregious arguments about tribal ecological knowledge. They said it's made up. It's a tool of the left to integrate their own policy priorities. So there's a lot of, I would say there's some really disgusting language in this complaint. That said, what they're asking the judge to do is to vacate the rule, meaning strike it down, and actually reinstate the Trump 2020 rule. So we don't know yet what the judge will decide, but we are in an environment where after the Supreme Court has issued a host of decisions around limiting agency authority and elevating the power of judges to strike down rules they disagree with, there's a new vulnerability that didn't exist before. So we have to wait and see. The other piece of litigation I want to flag is that the Supreme Court actually recently accepted a case that argues that NEPA, the law, does not require agencies to analyze the impacts of actions if they don't have authority over those impacts. And that sounds wonky, but what it means is if the court agrees, then agencies that don't have authority over, let's say, cumulative air impacts, don't have to even think about them. Agencies that don't have authority over environmental justice, which I would say a lot of conservatives might argue they don't have authority over, they no longer have to analyze environmental justice related impacts. So it's a very powerful argument. And we know the court has been on this bent to reduce the scope and power of our bedrock environmental laws. So I am personally very, very nervous about this particular case that will now go before the Supreme Court.
I guess I'm not understanding because what I heard you both say is that in 2023, there were statutory changes to NEPA, which has led to the Phase 2 regulations. And so if they're challenging the Phase 2 regulations and suggesting that it gets thrown out to go back, how is it possible to go back to a prior rule if the Phase 2 rule is about the implementation of updated statutory language? You two are both attorneys. Help me understand that. I mean, I think there's a lot of flaws in the argument in the North Dakota case brought forward by Republican states, but I think I'm just trying to understand the procedural nature of what I'm hearing. It doesn't make a lot of sense to me.
I think it's ideological in the sense that a lot of the challenges that are being brought, in particular in the environmental space, are about the scope of agency authority. And by that, I mean when Congress passes a law and tells an agency to do something, there is a debate around how much authority Congress has delegated. So the argument that these Republican states have made about NEPA Phase 2 is that CEQ took that delegation from Congress and took it too far. There's language in the statute. CEQ read effects, for example, and said, well, that includes indirect effects and that includes cumulative effects. That's language from the 1978 regulation. But they argue, and the Trump administration argued in the first round and have promised, if they win again in Project 2025, to abolish the consideration of cumulative impacts because they say that is not authorized under NEPA. So it's a debate about what the law means. And one of the fundamental arguments for striking down these environmental rules is that the Biden administration has taken their executive authority too far. Government has gotten too big. What that does is it fundamentally hampers the ability of these agencies to tackle big, urgent problems like climate change that aren't explicitly contemplated in laws written in 1970 or 1990. And so that interpretation, that sort of idea of how government should work is really harmful in an era we have lots of really, really big, urgent problems.
So you could technically pass policy in the 70s and then have rulemaking, and then later on down the road, revisit those rules and interpret the policy differently under a different administration. Is that correct?
I think so. There's a lot of back and forth under Obama versus Trump versus Biden. That back and forth is agencies reading the law and interpreting it differently based on their policy priorities. Because there's a lot of ambiguity. Like, for example, in the Clean Air Act, what is the best system of emission reduction? That changes based on your priorities, based on what technology exists at the time, based on the data that you have in front of you. So some of it is ideological, some of it is just the passage of time. And in theory, the law is supposed to allow for that flexibility because the world changes.
I think the thing that's a little more troubling is that they change based upon the administration and then who's running those agencies. Because I think from an advocate's perspective, we work so hard to pass policy, and if we can, we stick with it through the rulemaking process, and then you have to monitor it and you have to focus on enforcement. And I think that this recognition that advocates need to have, which is then still not done. There's the enforcement part, but then there's the ability to reinterpret policy under different administration. And so I think that it's so common of those of us who do advocacy to almost move quickly from one thing to the other. We tend to not do the regulatory step. We don't do the enforcement step. And we certainly aren't monitoring when they're being implemented differently under different administrations. And that's at the state level, federal level, local level. So I think this is a very interesting conversation just generally about policymaking and enforcement. So how can community groups stay connected and informed on NEPA?
One of the ways to stay informed and up to date on NEPA is, especially at the community level, keep an eye out for new projects coming down the pipeline that are major federal actions, and use the NEPA process to really help shape the projects in your community that may be coming down the pipeline. I want to touch again on one of the important ways that communities use NEPA and in the litigation aspect, kind of seeing now how the notification processes and procedures are going to be implemented so that EJ communities are up to date. I want to bring the example of communities in the San Bernardino area down here in Los Angeles. These community members found the notification of the expansion of a major freight airport in the back of a newspaper, in a very tiny section of the newspaper there. They ultimately challenged this decision, through going through the NEPA process. And unfortunately, the lawsuit was not successful. But I think I wanted to raise this important point because the dissenting judge, Judge Rawson, she said, I do not say this lightly, but it must be said, this case reeks of environmental racism, defined as a creation, construction, and enforcement of environmental laws that have a disproportionate and disparate impact upon a particular race. And then she again observed, Does anyone have doubt that this environmental analysis would have not seen the date of light if this project were sited anywhere near a wealthy enclave where multi-billionaire owner of Amazon resides? Certainly not. And so I think this is just a really, really powerful statement that even if the community lost, there's a lot of hope there that a judge in the Ninth Circuit saw the impacts that a NEPA project was going to have on that community and stood up and said something about how dangerous this project would have been.
Yeah, such a powerful statement. Thanks for sharing that. And I think it's just also so interesting to me in this equating it with what the experience might be for people with lower incomes, BIPOC communities, and wealthy communities. I think that same goes if we were for investors in corporations. An investor in a corporation would never stand for a lack of information about the impact of their investments. And so we as taxpayers are investing in these projects and programs through our tax dollars and equally should be abreast, should be aware of what the implications of our investments are. And so I think that standard practice is something that is not unusual, it's not radical, it's pretty straightforward. And so I think the basic construct makes a lot of sense to me. So on this court case in North Dakota, I assume with your suggestion of the judge, how they will rule, obviously appealing that is probably not going to help its chances. So what's your sense of how that's going to unfold? I mean, I think it's important for people to understand that technically the role of the courts is to interpret policy and for legislators to make policy. I assume that the pathway would be for legislators to pass clearer, stronger policy. If the court pathway is essentially blocked for protecting these improvements to NEPA, then it has to be a legislative pathway. And I think that to me, as disappointing as that may seem, I think it reinforces the role of organizing and advocacy work and our listeners who do that work to be able to keep the pressure on to just make sure that this issue is something that has the public demand that will be required for it to go back through Congress again, which is unfortunate because the action was taken and now we have to do it. But the process of policymaking is for us to learn from that and to make the policy stronger and better, more ironclad. And so I think there's an opportunity for us as advocates to be able to lean into that and to have to just go back to making that happen.
I think that's right. And I would add two things. One, I don't want to create the impression that the litigation pathway is irretrievably broken. We have a much steeper battle given the makeup of the federal judiciary, but there are some really good arguments to be made against the claims that this phase 2 rule is a fundamental sort of mutation of NEPA, of the language of the statute. I don't think that's true. I think there's a lot of arguments to be made, for example, that these states don't have standing yet. Like the rule just went into effect. Nothing's happened. No harm has occurred. And so first, I would say the lawyers who will be defending this rule, the DOJ attorneys, they are just putting their nose to the grindstone and trying to figure out, okay, we have a new legal environment. What do we do in that environment? And there are absolutely still very good arguments to be made, and they should make them. That, of course, leads to my next point, which is elections matter. The DOJ defending this rule will be made up of policy people appointed by the next president. So it matters in that way. It also matters in terms of these staff and these agencies who are really doing the critical work of raising up these EJ priorities, making sure that this consultation goes the way it's supposed to. So if I can make just a really bald push for folks, is not just to continue to advocate from the outside, but look for opportunities in public service in the government. Because we need people with AJ experience to fill these roles, whether it's in the state or in the federal government.
Thank you, Hannah and Idalmis, for being with us today, and thanks to our listeners for joining us on the Just Solutions podcast. Special thanks to our producer, Taylor Ward, and our recording engineer and editor, Angel Batista. If you enjoyed this episode, leave us a review wherever you listen to podcasts. If you'd like to know more about our work at Just Solutions, visit our website at justsolutionscollective.org. You can also follow us on Instagram, LinkedIn, Twitter, and Facebook for the latest updates. Together, we are driving community-created and equity-centered solutions to the climate crisis. We hope you'll join us for our next episode.